All right, so as I said, the administrative regulations can exist at the city level, at the county level, state level, national level, and these agencies come up with their own set of rules for how they're going to operate. Those are administrative regulations, and that's one place where we can laws. And of course, statutes. Statutes are uh, laws that are created uh, by the legislature that are codified. And so, for example, we have a set of statutes known as the Penal Code. And um, tells us what things are against the law in a particular state. So have a set of statutes known as the Evidence Code, which tells courts within a particular state how to operate, what types of evidence to allow, and what types of evidence um, to exclude. And finally, the individual rights. The sources for individual rights are things such as case law, such as the U.S. Supreme Court, citing that same-sex marriage is the constitutional right. Also, of course, case law, or sorry, I reset that one, court rules, legislation that maybe gives us a right. For example, in California, trans individuals can use whatever restroom is consistent with their identity, their gender identity. And then, of course, federal constitution we know, but also state constitutions provide, depending upon the state, it may provide even more uh, protections or individual rights than even the federal government. All right, so now I want to make sure that I go to the that are some of the most important ones in the Constitution. The first, the fourth, the fifth, the sixth, and the eighth. Okay, so this is the language, you can read it, but here's essentially what the First Amendment is focused on, freedom of religion. So two things here. Government cannot establish a religion, but also government can't interfere with an individual's religious practices. So government's not supposed to promote religion, also not supposed to destroy or try to prohibit somebody to practice. Okay. It's pretty simple, sounds pretty simple, but it's not always as well established as we think. In fact, the U.S. Supreme Court decided a case earlier this spring that dealt with a football coach who often prayed on the 50-yard line after a game. Invited players to join if they wanted to. And so that case was decided in favor of the coach. It was decided by the 6-3 majority, or 6-3 decision, that the coach had the right to pray, that the coach was not infringing on anybody else's right because it happened after the game, and this idea that students might feel that players might feel that they should, or they had to, decided was neither here nor there. All right, so, we also, of course, have freedom of speech. Under the First Amendment, we also have freedom of association, and about freedom of speech. And in fact, when you think about any of these rights, none of them are absolute, meaning that there are sometimes, well, there are going to be times when there are um, situations where maybe they can be infringed upon. So if you think about free speech, you don't have the right to, from a very well-known case, you don't have a right to go running through a crowd, place fire, and cause a commotion where people get injured because they trample one another trying to get out. That's not constitutionally protected speech. However, you can burn the U.S. flag because that is symbolic speech. Okay, and again, not everybody agrees with the U.S. Supreme Court decisions all the time. I happen to agree with that's the Texas versus Johnson case in 1989, but there are many people who think the burning of the flag is terrible and should not be allowed. Second Amendment, we all know is about guns. Here's the language to the amendment. What most people don't know, if you read that really quickly, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So really this clause is, this amendment is talking about a well-regulated militia. Because remember, after the colonies had won the American Revolution, they didn't have a militia, they didn't have an army, they didn't have a navy, etc. And so the thought was, hey, the monarch might try to take us back over again and might try to start a war with us, and we don't have an organized militia. So the reason we won last time was because we had our own guns and we could organize with one another. And so we need people to be able to keep those arms again, just like we did before. Um, what most people don't realize is it wasn't until 2008 when the U.S. Supreme Court, in this case, remember it's 2008, District of Columbia versus Heller, where the court finally said, okay, we're holding that the Second Amendment does protect the rights of individual gun owners. And the court said militias are just one reason for the need of protection. But the court prior to 2008 had not actually said that there was a right to individual gun ownership. Assume that Second Amendment has always meant what we think it means today. Third Amendment is really inconsequential because it's a product of its time. It's about having to house members of a militia in your home. It's not going to happen. Fourth Amendment, here, the language, but let's get to the issue, the part that's most relevant. First of all, First Amendment is protecting us from unwarranted searches and seizures of our unwarranted searches of our person or our property, but also unwarranted seizures of our property. So in order to be searched, that something that we have done something wrong, or we have something um, that we're not supposed to have, or we've done something we're not supposed to have done. So probable cause is what is needed, meaning that there has to be some articulable evidence as to why search must be conducted. It can't just be based on gut feeling. It has to be based on some sort of evidence that there's something wrong here. This person did something that they weren't supposed to have done. So here's a quick example. If you're stopped by a police officer speeding, say, and the police officer says to you, hey, since I have you pulled over, I'd like to search your car. You don't have to say yes. You can say no. Why? Because the officer has not told you, hey, I suspect that you have contraband in the car based on X, and so I need to search your car, step out of the car. Most people say yes, though, because they think they have. Here's when there is probable cause. If the officer pulls someone over for speeding and, unbeknownst to the driver, as the person stopped, an open container rolled out from under the front seat, the front passenger seat. So say an open beer can that's empty, or an empty beer bottle that's empty. Well, then that's probable cause. The officer can see the open container, and so the officer now has a reason to ask the person to step out of the car and to give the person a sobriety test, and to also look to search the car to see if there's more alcohol. So you can see the difference between probable cause versus the gut feel, or just asking because. Fifth Amendment, here's the language, but let's get to the chase here. Rights associated with the Fifth Amendment, indictment by a grand jury. And this is really only done in jurisdictions today where it's a very prominent case. Okay. Most criminal cases today do not require going before a grand jury. And this is almost always done in federal cases, but not very often in state cases. Also, freedom from double jeopardy, meaning that you cannot be tried twice for the same crime that arises out of the same set of circumstances. That's a piece that people always forget. What that means is if you're acquitted by a jury for murder and 3 or 4 years later, new evidence comes to light, you can't be tried because you were already found, you were already acquitted of that same murder. On the other hand, if you're acquitted of murder of Mr. X, and 3 or 4 years later you're now accused of the murder of Mr. J, well, then you can be tried because these are two different people that you're alleged to have killed. And of course, the right to due process and just compensation. Okay? And then finally, privilege against self-incrimination. So you can't be made to testify if anything that you might be asked about might incriminate you. The right to due process is this idea that you have a right to all of the rights that are provided to you in the Constitution. We can't just pick and choose which rights to give you. We have to give you all of them. And just compensation is referring to eminent domain, which we're not going to spend a lot of time on right now. So, all right, self-incrimination. Sixth Amendment, language. Now we move to the idea of what are the rights in that Sixth Amendment. First of all, right to a speedy trial. You're not supposed to be held for unnecessary long periods of time. Speedy, though, is all relative. In California, in LA County, it's not uncommon for people to wait 2 to 3 years for a trial. And if you can't afford bail or you're not allowed to be out on bail, then you're going to sit that time in county prison or county jail. Also, a right to notice of the charges. You have a right to know what you are being charged with. They can't just put you in jail and say, okay, we're going to give you a trial. You got to know what you're being charged with. Also, a jury has to be selected from the community in which the crime occurred. Now, people always say a jury of your peers. It's not quite the same thing. A jury of your peers would mean people who are similar to you. That's not what the Constitution is requiring. It's requiring people be chosen from the community where the crime occurred. So you're tried where the crime occurred, and the people who are going to judge you are from that community. Doesn't mean that they're your peers. All right, and people have to be chosen to be on the jury who are not biased. That is, they're not predisposed to judge you guilty, and they're not predisposed to judge you innocent. Because they know you, because they feel good about you, or because they hate you. They're supposed to be neutral. Also, you're supposed to be able to get assistance of counsel. If you can't afford it, then it's got to be provided for you at the state's expense. This might be sounding familiar to you if you have taken any criminal justice courses or even administration of law courses, because they're part of the Miranda rights that people have to be read. Seventh Amendment, I'm not going to spend a lot of time on. It's mostly dealing with it deals with federal trials. Here's the Eighth Amendment. Excessive bail should not be required, nor excessive fines imposed, nor cruel and unusual punishments. I read this one because it's short. Right to bail. You don't, there's a prohibition on excessive bail, but you also don't have the right to bail. Meaning that if you're charged with a particularly egregious or heinous act, the judge may decide that you don't get the right to be out on bail. It seems to happen to people who kill them often as to what we like to, but that's just there's evidence out there, but no time to go through that. Also prohibits torture and punishment that's disproportionate to the offense. So, for example, the Supreme Court has ruled in numerous cases that the death penalty is not appropriate for rape. Death penalty, we don't think of death for stealing. It's not proportional to the crime. The Eighth Amendment doesn't prohibit the death penalty, though, and the Supreme Court has also made that decision. All right, so let me get to the 14th. What abolished slavery? And the 14th Amendment, very nice and lengthy, so let's focus on the nitty-gritty. 14th Amendment forbids from mistreating citizens. States can't deny citizens due process of law or equal protection. And relevant clauses, the due process clause, which incorporates many of the provisions of the bill, it's making them applicable to the states. The Equal Protection Clause, which bans states from making arbitrary and reasonable distinctions between people, and the Privileges and Immunities Clause, which discuss in a later chapter. The Equal Protection Clause is very important, and we still see a lot of constitutional cases that are argued before the Supreme Court based on the Equal Protection Clause. It's this idea that because of segregationist laws, the 14th Amendment was passed. It's this idea that a state can't tell kids from one background, say, I don't know, kids of color, that you have to go to this school, but white kids go to school over here. They can't, there's no reason. It's arbitrary. It's unreasonable. What are they, because kids of color, you aren't good enough to go to school with white kids? That doesn't pass constitutional muster. And then finally, the standards of review, because the Supreme Court does not review each case with the same standard of review. It depends on what kind of case it is. Yes, they're all constitutional issues, but there are 3 levels of review. Strict scrutiny is the highest level of scrutiny that the court uses, and this is typically used for race and religion cases based on race and religion. So the state cannot enact laws that abridge the fundamental rights of an individual unless it has a compelling interest to do so, and unless that law is narrowly tailored so the right is not abridged more than necessary. Okay, so we think about this case. This is a case from the early 1990s that subsequently